Hi there, my name is James Folds, and I'm going to be presenting on Chapter 29 from our textbook, which is entitled Creditors Rights, though the chapter actually covers creditors and debtors' rights. So, a debtor is defined as a person or enterprise that owes money to another person. So it could be an individual, a business, a government, or anything like that. Pretty much, if you've ever taken out a loan for anything, or if you've ever had to pay a bill, or even if you've eaten at a restaurant, you've been a debtor. A creditor is the opposite. They're the person, or the other side of it, not the opposite, but they're the person that's lent out the money or extended the credit to another party. Most of the time, businesses, they'll be debtors and creditors. They'll have to buy product, and they're usually invoiced for that by whatever company they're buying it from, or buying materials or anything like that. And then when they perform a service or they sell a product, they often become the creditor. Another person will pay for a service and then they'll be invoiced. In order for commerce to happen in our society, these two relationships pretty much have to exist. Now, most of the time, the relationship between the creditor and the debtor works out just fine. The business will perform a service or sell a product, and an invoice will go out, and the debtor will pay the bill. And even if it's late a little bit or only partial payments once and again, eventually everything's paid up, and most of the time it goes on just fine. But sometimes, for whatever reasons, a person or a business, they're unable to pay all the debts that they owed. In a case of an individual, maybe they came down with an illness and weren't able to make any income, and the bills just piled up. Or a business may have performed a big job for another company, and that company wasn't able to pay, so in turn the business that performed the service, it's unable to pay its debts. So there's a whole variety of reasons why it might happen, but sometimes it does happen. And what happens then? When a debtor becomes unable to, for whatever reasons, pay their debts as they fall due, or when their liabilities exceed their realizable assets, they'll be what's called insolvent. Likely when this happens, some creditors inevitably will go unpaid. So what happens next? Well, that's when the law kicks in. There's a whole bunch of different laws that, depending on the situation, will cover what happens next. There's some things like the Companies Creditors Arrangements Act, the Builders Lien Act, the Bulk Sales Act, and some international laws that would cover international bankruptcies. The main one that applies in Canada on a federal level, and the main one that the textbook covers in this chapter, is the Bankruptcy and Insolvencies Act. So when a person or business becomes insolvent, there's going to be a bunch of different competing interests in the matter. One of the obvious ones is the creditors. They're going to want the money that they're owed, and they're going to want it as soon as possible. The business owner, or the person who's become insolvent, they're going to want to try to salvage what they can of their business, and probably if they can't salvage it, have a means of getting out without losing everything and starting again fresh. And society in general has an interest. If a company employs a lot of people, then it's in society's best interest to see that these people can somehow keep their jobs. And if the debtor has committed fraud or has been dishonest in some way, it's important for society to be able to punish people for those type of acts in order to deter it from happening again. So in a nutshell, what the Bankruptcy and Insolvency Act is doing is it's trying to balance all these different interests that come up when a person or a business becomes insolvent. Its purpose is to provide a way of releasing an honest debtor from their obligations after all their assets have been distributed to the creditors. It also provides a uniform practice for these proceedings for bankruptcy and insolvency throughout the country and tries to make it as inexpensive as possible. It provides an equitable distribution of the assets among all the different creditors that might be involved. It provides a framework that's acceptable to the creditors for hopefully reorganizing the debtor's business or affairs in order to avoid liquidating everything, if that's a possibility. If none of that can happen, then it aims to provide a release for an honest but unfortunate debtor, and offers them a fresh start once everything's been sold off and paid to the creditors. And like I mentioned before, it also provides provisions to punish dishonest debtors and prevent them from re-engaging in business. So for supervising the bankruptcy proceedings in Canada, the Superintendent of Bankruptcy works under the Department of Innovation, Science and Economic Development Canada, and that person or their office provides the general supervisory function over all the bankruptcy estates and proceedings in Canada. They basically their department's responsible for issuing licenses to trustees, developing policy, and basically supervising the whole act and its implementation, I suppose. Below them is the official receiver, and for the purpose of the act, every province or territory in Canada is split into districts, and some of the districts, the big ones, are split into different divisions. So each division is headed by an official receiver, or several, and they're officers of the court. And then below them is the trustee in bankruptcy, and these are the licensed professionals, usually accountants, and they're the ones who actually handle the administration of the debtor's estate. So under the Bankruptcy and Insolvency Act, there's three main procedures that are available. The first is what's called a proposal, and this is basically an attempt to avoid going through the whole bankruptcy process. So it's in everybody's best interest to not have to go through the bankruptcy process. So what happens is it's basically a chance for the debtor to attempt to reorganize their business or their personal affairs and carry on business in a way that they can pay back their creditors. If they can do this, like for example, a medium-sized business might sell off some of their departments that aren't doing so well, take that money, reinvest it, and get back to their core business, they might be able to start turning a profit again. And if they can do that, then they can pay back their creditors. And this is in the creditors' best interest because they want their money back, but they want it back dollar for dollar what they put in at least. And that doesn't usually happen once the bankruptcy proceedings initiated. It's usually a sell-off, and they'll get back a portion of maybe what they put in. The second is an assignment. That's a voluntary application for a debtor to go through bankruptcy proceedings, and it's not really that uncommon, especially with personal bankruptcy. When a person just gets overloaded with debt and they know that they can't pay it, then they'll initiate the bankruptcy proceedings so that they can get it over with and get back on their feet. Third is the bankruptcy order, and this is when the debtors they petition the court to have it's when the creditors petition the court to have the debtor declared bankrupt so that they can start the liquidation of the assets and hopefully recoup what they can. So once bankruptcy proceedings have started, this is when the trustee comes in, and that's the person, like I mentioned a couple slides ago, they're the ones that are doing all the hands-on work regarding going through the bankruptcy process. So what they'll do is a trustee takes over control of the debtor's business or their personal affairs if it's personal bankruptcy, and they essentially act as the manager in the business for the duration of the bankruptcy. First thing they'll do is collect any debts that are owed to the business. So they'll go out and try to get as much money paid back as they can. Another thing they do is they scrutinize very heavily any records for transferred undervalue and fraudulent transfers. And this is pretty important because if a business or a person knows that they're going to be going through bankruptcy, they might try to hide a lot of their assets. So they might say, sell off 100 stereos at a fraction of the price to one of their buddies and get it back, or something like that. It's ripe for fraud. So they'll scrutinize everything like that, just to make sure there's nothing dishonest being done. And the last thing that they'll do is basically they'll sell off or liquidate all the remaining assets. So everything that the debtor owns or the business owns, they'll sell it off, basically try to get some cash and pay back the creditors. Now there are exemptions from this, and the provinces they list the specifics of what can be seized and what can't be seized as part of the bankruptcy. One example is some provinces will say for a tradesman's tools, for example. So if you're a mechanic by trade and you're going through bankruptcy, you might have easily $10,000 or $15,000 worth of tools, but those aren't just assets. It's also the way that you earn a living, and part of the Bankruptcy and Insolvency Act is making sure that people can start out again. So you don't want to be taking away a person's ability to earn a living. Some other things like that specifies, I think provinces will specify a vehicle can be kept, but it has to be a maximum value of, say, $7,000. So if you've got a couple Lamborghinis in the driveway, those aren't your personal vehicles to get you around. They're assets and they could be sold. But if you have a modest vehicle that you need for transportation and getting to work, a lot of provinces allow that to not be seized. And things like pensions or your RSPs, they're not seizable except for 1 year's contributions. And I'm assuming that the reason for that 1 year is if somebody knows they're going to be declaring bankruptcy, then they may try to put as much money into their RSPs as they can if it wasn't touchable. So it allows a bit of a buffer for that. Once the trustee has liquidated the assets into cash and collected any amounts owing, then the process of paying out the claims to the creditors starts. There's a priority in which creditors get paid. It's one of the main parts of the Bankruptcy and Insolvency Act. So first priority is what's called super priority claims, and this would involve, first of all, unpaid sellers. And they're at the top of the list because this is basically a repossession. Like when a seller, say for example, a chainsaw business goes bankrupt, Husqvarna or whoever the wholesale seller of the chainsaws is would be able to go in and repossess all the chainsaws that they delivered that haven't been paid for if they're in brand new or the same condition which they were delivered in. So that makes sense. Second priority is wage earners. So any employees of the business, they're entitled to the first shot at some of the payment, but not all the wages that they're owed. In the super priority category, a wage earner is a maximum of $2,000 that they're allowed to collect at that level. So not a whole lot in today's money if somebody hasn't been paid for a couple months. And then there's interim financing creditors. And these are creditors that have maybe made a loan as part of the proposal. So a restructuring right before bankruptcy, it would be a very high risk loan to give. So part of the encouragement is, or to give that loan and allow a business to try to restructure, is that if things do end up going to bankruptcy, those creditors will be some of the first ones to get paid. Second, then you have secured creditors. So that's anybody that's lent money and they have some sort of security. So for example, a business or a person, real estate's a very common one. You might have a house that you owe a mortgage on. Well, the security is the house and the loan would be the mortgage. So if the mortgage isn't being paid, then the secured creditor could go in and repossess the house. So or the office building or whatever it may be. After that, you've got a whole list of what are called preferred creditors, and there's a list on 691 in the textbook. But some of the examples are funeral and legal expenses if somebody was bankrupt when they died, child support payments that are owed, rent owed to landlords. These all come under a preferred creditor. And I believe that actually this is also the preferred creditor category is when wage earners can go back and get the rest of the money that they're owed if there's any left. General creditors is basically a catch-all category for anything left that hasn't been paid. And then deferred creditors are creditors that aren't necessarily at arm's length to the debtor, is how it's used. So, like maybe business associates who have given loan or who have given loans, or people like that are closely related to the business, they'd be the last ones to get paid. So the final stage of the bankruptcy proceeding, once all the assets have been sold and the creditors have been paid off the best possible, is what's called the discharge of the bankrupt debtor. And this is where everything's said and done. The debtor gets to keep the basics of what they need, and everything else is sold off and paid back. The debtor is released from the debts, and they get to start again with a clean slate. Not everything, though, is wiped clean. There are things, and it's all detailed in Section 178 of the Act, but basically any type of debts owing that came from like civil lawsuits, for example, where the person has done physical harm or violence to another person, or things like child and spousal support that hasn't been paid. It wouldn't apply to civil lawsuits for other things, like if you're awarded damages or like other types of damages, basically, that don't involve some sort of physical harm. And student loans is the other one. So student loans aren't dissolved or forgiven because a person's gone through bankruptcy. Not right away anyway. The Act allows for student loans that are still there 7 years, I believe it is, after the person's completed school, but not for those first 7 years. So somebody, because of going to school, that's what caused them to have to declare bankruptcy. Those loans aren't forgiven. So that brings me to the next slide, which is the ethical question that I kind of want us to think about or talk about as part of the presentation. So the ethical question, or the ethical issue that we wanted to bring up as part of the presentation, is the same one that the textbook uses on page 693, and that's: does the Bankruptcy and Insolvency Act discriminate against students? In 2005, the Canadian Federation of Students challenged the law as being discriminatory under the Charter. It never went through the courts very far. It was dismissed. But as we've talked about in the course, matters of law and matters of ethics are not always the same thing. So putting the law aside, do you think it's ethically right for students to be lumped together with deadbeat parents, people who have been civilly made to pay money for crimes and for harming other people and things of that nature? And what are some of the possible reasons or justifications you can think of for not allowing student loans to be discharged? And if I'm able to attend class, hopefully I'll be able to join in the discussion. If not, if you could just have a quick discussion about this and express your ideas, and maybe throw them up on the bulletin board. And yeah, I think that's about it. Just one small bonus, I guess, is there's a link to an article. Originally, my presentation date was supposed to be back in October, I believe, and that's when Sears was going through its bankruptcy, and there was some pretty topical news stories that I was going to use for the ethical issues, but that's kind of blown over, so I decided to go to use the student one because it relates to all of us. But you should be able to access the link to a news article, and it just basically goes over the whole Sears bankruptcy and the pensions and why those were in danger. So if you wanted to have a look at that, that's just something that might interest you related to the topic. Other than that, thanks a lot for listening, and I look forward to the discussion. Bye-bye.